you please look up this sign?
See if we can figure out something.
Hi. I was listening to a really, really random, like super random hearing on, what even was it about? This guy basically, he is suing the hospital he used to work for, and that is because of a non-compete. And I got really sucked in, and so I didn't realize it was past 20 past. So I'm sorry, I need to turn off the live reactions. Awesome, that's off. And do that so that ads don't pop up. Right. Lilith, Evie, Stevie, and Chini, welcome. Guess what I got for my birthday? Actually, don't guess. Also, just to mention that my birthday is actually Tuesday, but today was family birthday party. I am down to do a haul. Can't show you until I plug this computer in. I'm down to do a haul, but it's not going to be like influencer hauls on YouTube, because we're normal people with normal wish lists, and I can't think of anything worse than having a $50 bajillion handbag. Well, that was weird. That looks a little bit like sparks. Always nice when you plug something in. There's going to be people in the comments of this video like, you were supposed to do this before your stream started. Yes, I know I was, but I didn't. What can I say? Before the stream started, I was doing Sunday chores. Oh, come on, hurry up. I'm excited. I want to turn this thing. Love all the guesses so far. This computer was just on. Okay, there we go. Just got to make the lighting appropriate. This is a slow computer. Shame, it's lived a good life. It's old. It's probably like 9 years, maybe even 10 years old. So otherwise I'm just going to join on my phone and take it from there. Okay. You can't see it yet. Just wait. Oh, I need to mute. Ta-da! Welcome to the 90s. I got a lava lamp. Hey, Bug. Yeah, and it's like, it's almost the exact match to that, which is so cool. And earlier, I used to have my record player where that lava lamp is, but it was always difficult to to let the lid open and whatever. So I moved it to the lounge. And so earlier I was playing my Alanis Morissette. My mom had to show me how to choose a song on a record player because, yeah, the 70s. Well, for me, it was the 90s. Actually, I think I got one for my 16th birthday. And my 16th birthday request was a room makeover. And I did the whole room in pink and orange. And my parents were like, those are two very random colors. And I pulled it off so well. It was very 70s looking. It was very like retro. Anyway, so that was one of my presents. Very cool. It takes a long time to warm up. Like, if you need a reminder of how instant gratification-y we are now, that's a good reminder, because we plugged it in and we're like, okay, let's go whenever you're ready. That's not the way it's going to play. I got very cool presents though. So where are we now? We're on day 3. That's it. That's all that's left. We have powered through this trial. Yes, it is. It's literally like on a record player too. Like, so cool. And it's a pink record player. I don't get this reference. In the diva. For me, it would probably be like the time of my life that this was. 16, I think. I was a little emo kid with the pink and orange room. Was I 16? Maybe I was younger. So this is what I said originally, and I was considering putting it on my desk, and then I was like, no. But for streams, it'll be so cool in a trial just to sit and stare at it. Look at it go, whoops. And they like bump each other. It's so cool. Oh, I don't know this. Oh, fun. I got such a cute plant thing as well. Right. Me too. I think I need more. I think I might have a bit of a lava lamp obsession now. I think this might be my new life. This might be my new hyper focus, because you get glitter ones, get all sorts. I think I should sit bottom corner. Can you see the lava lamp like that? Not that much. Okay, so closing arguments and the verdict. Yes, both sides have rested. And basically what I did was I outsourced the editing of this one, so I didn't see the verdict. However, I then saw the verdict yesterday. But what it means is I don't necessarily know how long there is and how much has been cut out. It looks like we go from closing arguments and then we come back to the verdict.
Morning, folks. When you came in the courtroom this morning, the court attendant handed each of you a set of jury instructions. I'm going to read aloud to you this morning the first about 80% of those. Then we'll stop. We'll do closing arguments from the attorneys, and we'll come back and read the last few. The reason we do it that way is the last few instructions kind of give you some direction on how you should start your deliberations and procedure for deliberating. The first part is more the meat or the substance of the law. So I'm required to read these to you out loud. You can follow along with your set if you'd like, or you can just listen, whatever works best for you. Instruction number 1, members of the jury, the trial information charges the defendant, Tyler Dazey, with the crimes of murder in the first degree and animal abuse. The charge of murder in the first degree includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. Instruction number 2, Tyler Dazey has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 3, the trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. The defendant has been charged with 2 counts. You must determine whether the defendant is guilty or not guilty separately on each count. Instruction number 4, Tyler Dazey is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5, you shall base your verdict only upon the evidence and these instructions. Evidence is 1, testimony in person or by deposition. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to, which were not offered and received into evidence, are not available to you. The following are not evidence. 1, statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom. Instruction number 6, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 7, as the defense said in their closing argument. So, Mr. Nelson, with that, whenever you are ready, go right ahead. Yes, please. Yes. You know what number that one is? By any chance? Number 1.
May it please the court,
Counsel.
ladies and gentlemen. First of all, I'd like to thank you all for coming in here and giving us your time. I know there's a lot of things you'd probably be wanting to do on a nice week like this, great weather, but this is a very important function, and we do thank you for coming in and giving us that time. Secondly, I'd like to thank you all for paying attention. Sometimes things get a little boring in here, and I was watching, everybody was pretty much locked in as the evidence came in. So this is the time where all the evidence is in, and now we attorneys get a chance to talk to you about that evidence. What is the evidence? We'll start with Exhibit 1. This is about Jennifer Dazey and her dog Echo. Ms. Lassance introduced you to them at the beginning of this case. You heard about her health issues. She had brain tumors. She had a surgery to remove those. She was recovering, moving forward in life. That all changed as a result of a particularly brutal and heinous act on January 18th of this year, which ended their lives. This is the front of 1605 Avoca, where Jennifer Dazey resided. On January 18th, her friend Christy Folman came by for planned coffee. They wanted to get together. Ms. Folman had been dealing with her own health issues. In fact, both of them had been in the hospital at the same time for their various health issues. They were just kind of getting back in touch, getting back together. They planned a coffee to sit down and catch up on things. Ms. Folman arrived. She noticed right away that there was a truck in the driveway and Jennifer's car was gone. That's Jennifer's son's Nick's truck. She didn't think much of it because vehicles got traded periodically there, and it was no big deal. Next. She walked up to the house. She went into the porch. This would be the front door that she got to. It would be coming in the front porch. She'd be right there, the front door of the porch leading into the house. She proceeded to open the door to go into the living room, and that would be what she saw. She opened the door. You can see into the dining room area. You can see the pillar in there that was talked about. Pillars that separate the living room and the dining room. So she was looking right in through there when she saw Tyler Dazey between the pillars facing away, and he was naked. She stood up and said, this is what she saw standing there. She was surprised and somewhat embarrassed when she saw that, so she started backing out of the door again. Then she heard some footfalls and she heard a door close. She thought, all right, it's safe to enter the house. She goes on in like she always did. Next. That's one too many. Oh, must have missed one. Anyway, she put her coffee down on the table. She took off her shoes, put on socks. That's when she saw the dog Echo on the couch under a blanket. She went over and picked up a leg of Echo and let it go, and it dropped. Now she began getting puzzled. She went to the kitchen. She looked and she saw that the door to the basement was closed, that she knew that Jennifer was not in the basement because anytime she went down there, she left that door open. She tried calling and she tried texting. When she came out of the kitchen, this is back in here, she looked over and saw right here a little nightstand sort of affair, which had Jennifer's purse on it. She knew that Jennifer never left the house without the purse. So now she was getting confused. She went to Jennifer's bedroom. The door was closed. That's an important point. So she went in the hallway, went down to Jennifer's bedroom. When she went in there, she called out softly. The blinds were drawn. It was dark. She was trying to wake Jennifer up. Hey, why are you still in bed? She could tell that Jennifer was in the bed, but she couldn't see any details. She moved closer, tried to wake Jennifer with a low voice. That's when she saw this. She closed the door, braced it with her feet, back to the door, feet on a dresser, called her boyfriend right away and said, I think Jennifer is dead. Get over here. Then she called 911 immediately, got on the phone. You heard the 911 call. I mean, that was sheer terror. That's the only way to describe that. You heard Officer Hesselbecker was dispatched, and he arrived at the scene shortly thereafter. Ms. Folman was on the 911 call, heard the officer enter the house, and she went to him and said, don't leave me. But the officer has a duty to do. He had to go investigate. So he said, go. And she went back into the kitchen, and she was hiding out back here near the pantry or mudroom or whatever they were calling it at the time. Officer Hesselbecker entered the room with his flashlight, turned on the light. That's the scene that he saw. You got to see that with the body cam that he was wearing. You saw the whole thing. You can look at it again if you want. You'll have that. We don't need to dwell on it here. You saw what he saw. He then called in and reported a homicide, and the cavalry started rolling. People started showing up. Lieutenant DeJuste arrived, assisted in clearing the house room by room. He announced numerous times, police department, make yourself known. Numerous times. There was no response. They cleared the basement. They cleared the main floor. Eventually, they got to the room, back bedroom that Tyler Dazey was in. Officer Slide and DeJuste cleared the room. You saw that on the body camera. They found Tyler Dazey face down naked. They thought it was a body at first. Then Officer DeJuste said he's breathing. They decided that they wanted to secure him under these circumstances. Mr. Dazey complied with instructions and directions. He stated his right wrist hurt. There were no bloody clothes found anywhere in that room. Then Mr. Dazey was ultimately placed in a Tyvek suit. That was to preserve evidence and just to cover him. Investigator Rosenthal noted at the time that Mr. Dazey had abrasions on the back of his right hand and the back of his fingers on his right hand. He was taken to Mercy Hospital to be cleared. He followed instructions up there. Officers obtained search warrants for blood and urine to check for drugs and to look for possible influence of drugs. While they were waiting there, Mr. Dazey stated that he needed to urinate. He was asked to hold it briefly so a sample could be collected. Mr. Dazey stated, "I'm letting go now. The keys are yours," and urinated in the tie-back suit. When investigator Rosenthal told him that he could have held it a little longer, Mr. Dazey responded, "Wars are meant to be fought." He urinated in the suit several more times, and eventually at the law enforcement center, he said he needed to urinate again. Officer Rosenthal said, "You don't need to do it in the suit again." He grabbed a collection cup, held it in place to get a sample. Mr. Dazey then said it might take a while and that he didn't want to dick you around. Then he said, quantum entanglement, brother," urinated all over investigator Rosenthal's hand. Samples were collected in that incident. They were sent to the crime lab along with blood samples. The lab results show that Mr. Dazey had ingested THC isomers of different types, which would be that contained in the gummies, the vapes, and probably from actual marijuana plants. These are these various modifications made to the THC. What they did not find was PCP, fentanyl, opiates, or any of the other hard drugs. So he was not under the influence of any of those things. Now, while all that was playing out at the hospital and the law enforcement center, investigators were working on the scene. Blood spots were found in the hallway outside Jennifer's bedroom, which would be in here. And they were also found in the dining room, living room area, going over to where the dog was found on the sofa. A hatchet was found on a shelf in the bathroom, and there was a sheath to that was found on the dining room table. Both of those items are in evidence, and you can see that the sheath matches the hatchet. The hatchet also says SOG on one side, which is the same brand as the sheath. The ring camera was checked and showed several things. One, it showed the switching of the vehicles at around 8 p.m. the night before, where Jennifer's son Nicholas came, dropped off his truck, and took her car. Something wrong with his truck. That would have been the evening of the 17th. Jennifer let the dog out and in at about 10 p.m. that night. Nothing happens on that ring camera until the following morning at 8:38 when Ms. Folman arrived at the house. Officer Hesselbecker arrived at 8:51, and you saw all those video clips, people coming and going at the front door of that residence. Nobody else went in or out that front door. It was not on the camera. It's motion activated. There was nobody else in or out. Exhibit 24 shows the back door to the house with the deadbolt vertical. The testimony was that the owner was contacted when I don't know what you call the thing, a thumb something or other, when it's vertical, the deadbolt is locked. That was locked when officers got there. There was no evidence of forced entry. You had officers on the perimeter when they got there. One of their functions is to check windows and doors and look for forced entry. They checked that on the interior. There's no evidence of forced entry. Tyler Dazey was the only living being in that house on the morning of January 18th. He told investigator Rosenthal that he owned a hatchet, which he last saw in his toolbox that morning. He also told investigator Rosenthal that he had just taken a shower that morning right before officers arrived. The hatchet was sent to the lab. Technicians could not state definitely if it had been cleansed or scrubbed. However, there was blood stains on the hatchet, on the head, the blade, and the handle. They didn't find actual blood, but they found the stains. So the question would be, how do you get stains on there unless at some point there was in fact blood on there? The blood residue or the stains was swabbed, and they found that DNA of Jennifer Dazey on the handle of this hatchet. There's marks on there. The DNA lab person said they're marked and they're numbered. That's where they pulled the samples from. They're little circles marked with some kind of a marker. Obviously, the hatchet was scrubbed in the shower. There had to have been blood on there to get blood residue or blood stains, and there was enough on the handle to get DNA from it. Not enough on the blade, even though they tried. Further, the handle of this hatchet had a right palm print on it, and they lifted that palm print and they checked it with known palm prints, and that belonged to Tyler Dazey. The lab tech couldn't say with certainty that the hatchet was scrubbed, but said the prints showed signs of either a wet hatchet or a wet hand when the print was left on the handle. Again, that was scrubbed in the shower. It came out, it was wet, the hand was wet. That's why we got the print on there, and that's why the tech saw that there was water involved when that print was put on the handle. Echo the dog was taken up to the veterinarian for examination. Dr. White determined the cause of death was sharp force trauma penetrating the skull. Maybe it was blunt force trauma, which was consistent with the spike on the hatchet, on the back of this hatchet, the spike being driven through the skull and into the brain cavity of the dog. Dr. Cruz, the medical examiner, performed an autopsy of Jennifer Dazey. She determined the cause of death was sharp force injuries to the head, face, and neck. There were 17 injuries, 13 of them to the face, head, and neck. There were 2 fingers amputated or nearly amputated. You saw those photographs. You saw, the autopsy photos. You'll have them again if you want to look at them further. They'll be with you. The fatal wounds penetrated Jennifer Dazey's skull and penetrated the brain, some 1 and 5 inches in depth on the forehead. The neck injury was 2 inches deep, went all the way to the vertebrae. There was damage to the vertebrae, but it didn't get to the actual spinal cord. The doctor also said these wounds are consistent with this hatchet striking Jennifer Dazey in the face and the head, given the width of the blade and the wounds that she observed. One of Jennifer Dazey's fingers was amputated completely and was found on the nightstand. Another was hanging by a piece of skin. There was another cutting wound near the thumb on that hand. The amputated finger was either severed with great force and ended up landing on the nightstand, or it was placed there, but it ended up over on the nightstand. The severed fingers are also consistent with blows from this hatchet. And if you look at the blade on that, the narrowness of this blade, and you look at a hand, you can see how this hatchet could have come down, taken those fingers off, and not affected the small finger and the index finger. If it were a large wood cutting hatchet, probably would have got all 4, but this particular hatchet, very consistent with those fingers and leaving the other 2 unscathed. It's clear from the evidence that this hatchet is the instrument of death for both Jennifer Dazey and Echo the dog. It's equally clear from the evidence that Tyler Dazey was the person wielding this hatchet. His palm print was on it. The DNA matches up, and he was the only one there, nobody else in or out of the house. He told Officer Rosenthal that he only slept about an hour the night before. He was in his room all night contemplating this attack. He took the hatchet from his toolbox. Naked, he went to the dining room where he removed the sheath and left it on the table. Then he proceeded to Jennifer's bedroom where he swung that hatchet 17 times, striking her in the face and head. She put up her hand at some point in defense. The hatchet came down, fingers came off. Given Mr. Dazey's statement, he's probably talking at the time this happened, calling her a whore or a witch before or during the attack. He left the bedroom. He was dripping blood in the hallway and the dining room, blood spots, when he came out and made his way to administer the fatal blow to the dog on the couch. Then he went to the bathroom, showered off the blood spatters. There was blood spatters on the wall, blood spatters on the jewelry box, blood all over everywhere. There had to have been a lot of blood over there with these 17 blows with this hatchet, including all over him. So he went to the bathroom and cleaned up. While in the shower, he cleaned the hatchet, cleaned the blood off, but he didn't get enough because the residue remained, the staining remained, and that's how we got Jennifer's DNA off of the hatchet. That was used to kill her. Left the palm print when he placed it on the shelf. He killed his mother with the hatchet. There can be little doubt of that. Now, let's take a look at your instructions. I'm not going to throw them up on the board and go through them. The judge has already read them. You're going to have them, but I do have to touch on some of them. The big one is instruction 15 for murder in the first degree. Element number 1 is on or about January 18th, defendant struck Jennifer Dazey with a dangerous weapon. You have to go to the instruction number 20, which defines dangerous weapon, any device or instrument designed primarily for use in inflicting death or injury, or any instrument actually used or intended to inflict injury or death. This hatchet particularly is designed as a killing instrument. It's got the big spike on the back. It's got SOG on it. In Army parlance, that's Special Operations Group. I'm sure the manufacturer is selling it to people as some kind of a battle hatchet. This is not a wood chopping hatchet. It's pretty obvious. It's got this big medieval looking spike on the back of it. But even if you believe that this is a wood chopping hatchet, then you have to look at it as an instrument used to inflict death. This is like a baseball bat. It's a baseball bat when used to play baseball. If you use it to bash into somebody's head, it becomes a dangerous weapon. So even if you think this is an innocent camping hatchet, it was used in such a way to make it a dangerous weapon, and it is in fact a dangerous weapon. Element number 2, Jennifer Dazey died as a result of being struck with the dangerous weapon. The medical examiner answered that. The cause of death was multiple sharp force injuries consistent with blows from this hatchet. Element 3, that Mr. Dazey acted with malice aforethought. You have to go to instruction number 16 for a definition of malice and malice aforethought. So that says malice is a state of mind that leads one to intentionally do a wrongful act to injury of or of another out of actual hatred or with an evil or unlawful purpose. So actual hatred. Mr. Dazey stated to investigator Rosenthal that his mother was a witch who put evil on him. He said he doesn't need her to validate him and asked why would he care what a whore thinks. He said, you want to sit and drink yourself stupid, fuck like animals and ruin your children's lives. Why would I care what a person like that thinks? He called his mother a whore often, said, you know how witches are. I'm better than you. I'm going to be your fear. I'm going to be your enemy. He explains his mother's injuries when asked as witchcraft. There's clearly hatred in those statements, but there's also the evil option or alternative. And I'll just simply state that 17 blows with this hatchet to someone's face, head, and neck is evil. And if it's not evil, evil doesn't exist. This was also a deliberated act, not in the heat of passion. You might be able to stretch it and say it was a heat of passion with one blow, but there were 17 of them. That's not the heat of passion. The time Mr. Dazey decided to pick up that hatchet and unsheath it and then go to Jennifer's room was when he decided to do what he was going to do. There's no limit required. There was malice aforethought before each blow, 17 times. He had fixed purpose and intent 17 times. He thought about this before he even took that hatchet out of the toolbox. That's premeditation. That's intent. He knew exactly what he was going to do. Also, you look at instruction number 19. In this one was used with malice, premeditation, and specific intent to kill. And malice aforethought is in another instruction, but the weapon itself allows you to make that inference. So the third element is satisfied. Element number 4 is the defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. We just covered some of that. Instruction 17 defines willful, deliberate, and premeditate. It's not accidental. 17 blows is not an accident. That's thinking about it 17 times. To deliberate is to weigh in one's mind, consider, contemplate, reflect. All occurred before he took that hatchet out of the toolbox, picked it up, took the sheath off, and went to do what he did. To premeditate is to think or ponder. Premeditation began at the beginning and followed all the way through after the murder of Jennifer Dazey to the killing of the dog. That shows premeditation because it didn't end with Jennifer Dazey's death. It continued on the whole plan to the dog. That's premeditation. It was the whole plan. Deliberation and premeditation need not exist for any length of time. You don't have to ponder this for days or weeks or months ahead of time. This can happen instantaneously before the act. As long as you ponder it and as long as you deliberate, that is premeditation. You go back to instruction 19, again, the inference. You may infer that the weapon was used with malice, premeditation, and specific intent to kill when a dangerous weapon was used and death results. Make that inference. Make it. Now, you've seen all the evidence, all the crime scene, autopsy photos. findings of the medical examiner, the veterinarian, all the lab people came in. There was a lot of evidence you heard. You've heard from police officers regarding their investigation. You've been instructed by the court with the law as to what the law is. You need to apply those instructions to the evidence. Tyler Dazey took this hatchet, dangerous weapon, with malice aforethought, premeditation, and specific intent to kill. He willfully administered 17 blows to Jennifer Dazey's head, face, and neck, killing her with this. Use common sense, use observations, use your experience, think it through, and find Tyler Dazey guilty of first-degree murder and animal abuse. Thank you.
Mr. Blair, whenever you're ready. Is it turned on? Test it. I don't know which number you have. He had one. I have two turned on.
What does it say on it? Got me now.
You're on.
I'm gonna set it down here. Hopefully everybody can hear me. May it please the court.
Counsel.
Counsel? Thank you. Could you actually, and I'll tell you, we'll want ours in a second.
I've got it on yours.
All right, but we don't actually want it up there yet.
Yep.
Just gonna have this in front of me, I guess. All right. Move that stuff over there. Okay. Starting off, first thing I need to say is thank you. Mr. Nelson already said it. I'll say it too. We talked about it a little bit during voir dire. Mentioned the fact that they wanted to serve on the jury because, among other things, it is their civic duty. I want to say thanks. The system doesn't work without it. I believe in the system. I have to believe in the system. We talked a little bit about what's different in our system and else's. I think that our system works. And we have an impartial trier of fact. You. And so I say thank you. I'm going to do what Mr. Nelson. All right. I'm not going to walk through the case step by step. To read to you from the jury instructions. I will talk briefly, very briefly, about one jury instruction. And I'm going to try to keep this relatively short and to the point. I only get to talk to you once. Mr. Nelson gets to talk to you twice. And after me. And that's he has the burden of proof. And we talked during voir dire a little bit about that burden, what that means, what that burden of proof is. All right. And you've got the instructions and you saw them. You can read how it works. Somebody, I forget who it was, right away when the question during voir dire piped up right away and said, when I asked, what does the defense have to prove? He said, nothing. That should be clearer now than it ever has been. Instructions. I say that because of one particular instruction. You look at jury instruction number 10, talks about the burden of proof and guilty beyond reasonable doubt. Only place this occurs in the jury instructions. And this is by design. In the second paragraph of that instruction, it says, a reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of evidence produced by the state. And yeah, I put emphasis on that. And then down in the last paragraph, it says, if after a full and fair consideration of all the evidence in the case, or
Okay, this is Evie's suggestion that I mute it and read the closed captions. So, yeah, I put emphasis on that, and then down in the last paragraph, it says, if after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, it's the only during where they do that themselves, that because that's the crux, they're trying to make sure you understand who has proof. What isn't just about having presented some evidence properly. Okay, it's did they plug all the holes? Can give you half of the puzzle.
remember, as you look at the evidence, and
Remember, as you receive the evidence and you're going to have a chance to take all of this stuff back with you, you all write, it's noted, the crime or how terrible the crime we all states, those pictures that they show them to you. The real reason of the crime, facts of the case. They want to engage emotions and not what it's really, really about. Whether or not the state has proven beyond a reasonable doubt defendant is the one who killed Jennifer Dazey. That's, remember, Mr. Ho's opening statement, I'm gonna talk, we're done, you're going to understand what okay, everybody does this. I understand that. Unfortunately, sometimes Dawn take the path of least resistance. Sometimes they take the easy way out. Is this working? Like, is this getting confusing? Because, like, I just need to know which is better, the sound cutting or me reading it. I can tell you exactly what happened here. It was a Bluetooth mic, and either the batteries weren't on properly or the Bluetooth connection was not working well. Sometimes you've heard the phrase, round up the usual, and it hasn't just survived from the movie. See right there where his mouth is moving and there's no closed captions? That's because there's no Bluetooth connection. This is why, for anyone who's ever planning a wedding or an event, if someone offers Bluetooth mic, no. Which take the easy way, they take the path of least resistance. It's how it's done. Unfortunately, going to talk about the certain items of evidence, you can see this pattern. You can see how this happened. For example, the first items of evidence we see in the case, we heard from Christy Fullman, and we heard from Officer Becker. Leave the video and CC. Okay. So we're gonna listen to him, let it cut, and have that on.
we also saw the ring cam video and Officer Hasselbecker's body camera video. And when I forget if he had one on when he came in here, but we got to see the body camera footage. And in all of that footage, one of the first things we see is Nick Frey's truck sitting in the driveway. All right. And Christy Folman and Officer Hesselbecker both told us about that they saw that as well. Christy Folman told us that the GMC not at the house. All right. Now, we know from Investigator Hoff's testimony that Jennifer Dazey went to Acadia and filled up the gas tank in the GM4 station because he went. With the interview with Nick Frey from the officers, Nick drops off the Acadia, evening of the 17th. All right. Of the officers reporting what they heard, I think it was Investigator Crable, reporting what he heard from Nick Frey, was that Mr. Frey had then driven, at some point, drives out of Dubuque towards Cedar Rapids. A big deal of the fact that they followed him on the cameras as he drove out of Dubuque towards Cedar Rapids. But you notice they didn't ever confirm where he went in Cedar Rapids or that he ever arrived. They didn't continue to watch the cameras when he came back. Whether or not he turned around and drove back. It that long. Interesting things about that whole scenario. To see a couple of clips of the ring camera footage. We were told that Nick stopped at the house and that there was ring camera footage from the front door of Nick exchanging vehicles. Did we? We were told about it. Does that seem like something that we should have seen? After he goes to Cedar Rapids, or in the direction of Cedar Rapids, go the places that he said that he was going to go, the things that he said he was going to do? Or did he turn and come right back? That seems like it's very similar. In their closing argument, the state just said Tyler Dazey is left or right-handed.
Okay, we're gonna skip this because it's so hard to hear.
And two investigators told us that it had just snowed quite a bit with several days. You can see the ring camera there in that picture, up in the corner of the door. You saw other closer pictures. I'm not going to page around and show you that. What I would note to you is a couple of things. The door is locked. But that didn't lock the door when they left out the door. All that requires is a key. Now, that leads to some interesting. The last we knew, and this would have been at the time Kylie moved out, but the only keys were in the possession of Kylie and Jennifer. And then we heard from Investigator Hoff, when he's investigating at the time of the incident, that there is a dispute because Kylie has never returned the back door key. Did anyone ask Kylie about the backdoor key? Did anybody get the backdoor key from her? Does that seem like something that we know? And if you think about it, I believe it was Investigator Hoff testified that at some point later in the case, he actually gets a key. Did you receive investigator? I forget what the question was.
This is so frustrating. He's completely cut out now. Completely. I mean,
Investigators talked about, and they showed us, there's actually a close-up picture in the evidence, and you can look at it, of that camera. It's a, right? Same brand, same, not the same type of camera, but the same system as the one on the front door. Investigators told you that they were able to get footage of the one on the front, but that they could not get any footage from the one on the back door. Now, the subpoena that they served on January 1st, January 19th, which not only would have covered the date of the incident, but it also would have covered the time that the officers were out there taking this. Should have been footage. Investigator Hoff tried to tell you, he got up there for direct examination, and he tried 3 ways that could happen. Either was taken, somebody hadn't paid for that. One of the examples I used was, I used one from my own life, and I asked him about it, but, you know, could I have the Ring camera app on my phone, and my wife would have it, and my daughter would have it, which is in fact the situation. And he said, yes, if I share it with them, they would all have it. It would require me to share it with them, but then they would also have access to that app, and any of us could turn off that camera. Interestingly, because about finding her phone, all right, did anyone even check Jennifer's Ring app on her phone to determine whether or not it indicated that the camera had been turned off, whether it was functioning, whether it was recording? Did anybody even check? Be nice to know that, wouldn't it? Another example in the evidence was the DNA print. Remember about my neighbor who wanted to sniff and feel my grass? And one of the pieces of evidence that we talked about at that time was my neighbor's ID that was found. The question was whether or not, what was the significance, kind of. I asked, does it make a difference if fingerprints are on the ID? Does it make if my neighbor's kind of correctly pointed out, well, no, it's the neighbor's ID. You'd expect to find their DNA and their fingerprints on it, right? In that little, you got to see, and you figured out the limitations of DNA and fingerprint evidence. All excited about DNA and all sorts of scientific, most of which is either completely fictional, yeah, in actual application, or is working. What we see in our case, we got to see the limitations on that type of evidence in great detail. We also got to see the way in which the necessary and fill those gaps. A minute. Do you remember item 7? First the DNA report, that was the blood drop on the floor in the living room, the one that was down near the couch. I think 4 in the picture. You can go back and look at those pictures. But what was interesting about it, during off, told us that it was sent.
I feel
The
like
experts, and they got the report back, and that was Jennifer Dazey's blood. Remember that? And then, when they got up there on direct examination, mistake. I don't think she meant to say it, right? But my memory at least is, and maybe you caught it, she actually went so far as to say, in referring to item number 7, that was Jennifer Dazey's blood. And so you probably noticed on cross-examination, I got a little ridiculous with her. I went go way out there. He couldn't say DNA. They didn't test for that. Is there determine whether it was human or animal? They didn't test for that. And it might have seemed a little silly at the time, but remember they swabbed Tyler Dazey's nose and it tested positive.
Okay, this is like worse than getting half the information. I just want to see if they created it with the transcript option on, which it doesn't look like they did. Let me see what I can do. Maybe ChatGPT can summarize it. Because this is awful. I looked for it everywhere because LNC was my least favorable option because they don't understand the rules of copyright. Okay, ChatGPT can't. Here's what I'm going to do. I'm going to copy the link to the original. Here is the original. If you want to watch the choppy one, I won't be offended, but this choppy audio it's just not making any sense. It's like here you'd say picking up storm peas, which is like at the end of the cigarette when someone's dropped it and there's like that tiny bit and you're just going and getting that like tiny bit. Like you're not getting information. You're not getting the whole thing.
And then return a verdict of not guilty.
Mr. Nelson, whenever you're ready.
First of all, there's an instruction that you need to look in there in that packet that says what we as attorneys say is not evidence. I gave you a whole lot of evidence. When I was up here talking, Mr. Blair gave you a big old mud ball against the wall. He's hoping something sticks. This was basically obfuscation. That's throw a whole bunch of static into this and try to picture something that it's not. He complains that it's everybody else's fault except Tyler Dazey's. First of all, inadequate police investigation. You all sat here, you heard from the investigators. There was an extensive investigation done on this case and everything points to Tyler Dazey. Now, the next claim is somebody else did it. Oh, it was Nick or Kylie. Well, why aren't there palm prints on this hatchet? pretty clear. This is the instrument that caused the death. Tyler's palm print is on the handle of that instrument. We heard evidence from experts, not from attorneys, experts that said how those palm prints can be on there, that there was water involved, either on the hand or on the handle. That's not Nick's or Kylie's handprint on there. The Ring camera was another thing. Who controlled that? Well, there was no code found for the phone. Nobody can look into Jennifer's phone to find out what was going on with that. It doesn't exist. It wasn't evidence. Again, well,
The objection's noted. Go ahead, counsel.
you have to remember, use your notes, use your own memory as to what was or was not in evidence. That's something that was not available according to my memory. Ring was contacted. They got evidence from them that said that there was no activity on that particular camera. There's all kinds of reasons why that would be. Maybe it wasn't paid for. Ring did not give that up. You have to pay an extra, $50 a month, I think was what was talked about. There's a lot of people have those cameras, decide it's not worth paying that kind of money, take it off. The lab tech, DNA, a lot of hay was made about, well, she doesn't test for blood. She tests for DNA. On occasion, she's going to test for blood, but in this particular case, she's swabbing. There was blood found on another test. She swabbed the stain, and on one of those stains on the handle, she was able to pull the DNA out of there. Okay, she doesn't go test whether it's animal blood or whether it's people blood. And during the course of that exchange, I asked the question, would you expect to find Jennifer Dazey's DNA in a drop of animal blood? Obviously not. We don't have to be experts to understand that. Experts talk in a whole different language than we do. When they say, I can't conclusively say that, what they can say is, well, I'm 99.9% sure, but I can't be absolutely conclusive. That's how they talk. Well, we can turn around and say here that, well, she can't be absolutely certain. Well, you see the difference. What the lab tech said was the DNA was found on the hatchet and it was swabbed from a blood stain. How could there be a blood stain on the hatchet if there had not been blood on the hatchet? Now, to talk about where it went, well, we're speculating more of the mud ball, hoping something sticks. I think we talked earlier about the video stuff. And I asked you early on, I said, some people are of the opinion in this day and age that if it's not on video, it didn't happen. Mr. Blair is pushing real hard for that. He wants you to believe that, well, if it wasn't on video, it didn't happen. This is a case where you're not going to have all kinds of video evidence. It's not available. This is old school. We have to go by all the evidence. You have to use common sense when you go through it. It's circumstantial evidence, and it all leads back to Tyler Dazey. Now, one of the big defenses in this case is Kylie did it. Well, Kylie lives across town. In order for her to do this, she'd have to slip away from her house. I mean, Investigator Rosenthal spent days going through traffic cameras, tracking her movements around town in order to eliminate her as a suspect. Days he spent digging through this stuff. In order for her to participate in this, to be part of this, she would have had to leave her house at the other end of town somewhere during the course of the night, through the back door, get out of a nice warm bed and get out into that cold air, and then sneak around through the alleys and through yards, and then get a hold of an Uber or a cab, because she didn't have a driver's license and she didn't have a car. How was she going to get across town? Okay, she'd have to go through all that, get over to Avoca Street. She couldn't get dropped off right out front, so she'd have to be dropped off blocks away perhaps, and then work her way over there. There were no tracks in the backyard, human tracks. She would have had to go up the driveway where she could have been seen, and then she would have had to enter the back door with a key that she may or may not have had. And then she would have had to go in, get a hold of her mom's phone or some phone, disable the camera, erase all the footage that was on that camera, and then go in there and sneak in to Tyler's bedroom, get the axe, the hatchet, out of his toolbox without waking him. And remember, Tyler said that he only slept about an hour the night before, an hour. So she would have to time that to get in there when he was sleeping during that 1 hour and get the hatchet out of the toolbox and take it out. She would have had to strip herself naked because there was going to be a lot of blood, and go in and commit this act and also kill the dog, and then go in and clean herself up, put the hatchet up there in the shower, go get dressed. Then she'd have to sneak back into Tyler's room, lift up his right hand and get his palm print on the hatchet so she could put it back in the bathroom where it was found. Now, Tyler also said He last saw the hatchet that morning before police arrived. How could he see it that morning in his toolbox when it was actually over in the bathroom? You know, it was a nice try. Let's throw this whole story together, but it doesn't fit. What we got here is a whole lot of evidence that got presented, a lot of evidence. It all goes right to Tyler Dazey, all of it. We're not here to eliminate everybody in the state or everybody in the country. That's not a function of law enforcement or my office. We're here to gather the evidence, and we're here to prove that Tyler Dazey committed this crime. We have done that. We have presented all kinds of evidence, scientific evidence, investigative evidence, physical evidence. It's pretty clear what happened here. Circumstantial evidence. Tyler Dazey was the only living being in that house. The only one there, nobody else. Nobody came in the back door. Nobody was sneaking around through the night. It's just not there. Look at this evidence for what it is. Circumstantial evidence. It takes us right to where we have to be. Mr. Blair says this is not about milk cows. It is, folks. All the evidence is there. There might be one or two little pieces missing, but when you look at it, that milk cow is right there, plain to see for everybody. Tyler Dazey committed this act. It was a heinous act. There's no other way that anybody else could have done it. It was him. The evidence points to him. It confirms it. Find him guilty of murder in the first degree and animal abuse. Thank you.
Okay, if you folks want to turn your instructions back to number 33, we'll read the last four. Consideration of the evidence with the other jurors. Shouldn't be discussion or deliberation about the case. You can look at the hatchet all you want, spend as much time as you need. When you're finished, tell the deputy thank you. He will leave again with the hatchet, and then you can start discussing the case. We do that because no one should know what your deliberations are and what you're discussing about this case, even the deputy who brings in a piece of evidence. I indicated to you about your phones. When you start deliberations, the court attendant will keep your cell phones. If you need to use your phone at some point in time, let the court attendant know that. She will let you use your phone. When you finish, you'll give it back to her and resume your deliberations. Deliberations can only happen when all of you are together. If someone needs to use their phone, use the restroom, step outside to smoke a cigarette, anything like that, deliberations about this case have to stop. You can only discuss the case when you're all in the same room talking about it. Throughout trial, I've been telling you about the admonition. This is the point now where part of the admonition changes. I had been saying, don't discuss this case with each other. Obviously, that changes. I had been saying, don't draw conclusions of any kind. Obviously, that changes. You still can't talk about it with anyone else. You still can't do anything to acquire any information outside of what you got through the trial process. Last thing is, there are 14 of you. By law, we have a jury of 12. We randomly selected who the alternates were going to be. Juror number 31 in the front, ma'am, you will be an alternate. And juror number 48 in the back, in the white shirt, you will also be an alternate. So that means when we're finished here and I excuse the jury, the two of you are released, entirely released from the admonition. You can talk to anybody about this case that you want, except the other 12 jurors. You can choose not to talk about the case if that's your choice. If you want to know what the verdict is, write your name and your phone number on your jury instruction packet and give that to the court attendant. After I take the verdict, I will call each of you if you would like to know and tell you what the verdict is, give you a chance to ask me questions or offer any complaints that you have. If you don't want me to call you and you don't care what the verdict is, that's fine. Then don't give your packet with your cell number to the court attendant. Make sure it's clear. The two of you should not express any thoughts at all about this case to the other 12 jurors. When we're done here, if you have anything in the jury room, you'll go in and get it, and then you're free to leave. Go home, go back to work, whatever you need. We will not be calling you back in, and you're released, but just don't express any thoughts about the case, any opinions to the other 12 jurors. The 12 of you should not start talking about this case in any way until the two alternates have left. Okay, I should say, I think you all ordered lunch, and even for the two alternates, if you want to stick around out in the hall, not in the jury room with the other 12, and wait for your lunch and take your lunch, you're welcome to take your lunch on the stage. If you don't care, you can take off and skip out on your lunch. All right, I have the verdict form. I am going to give this to the court attendant, and she will take you to the jury room at this time. Again, not yet brought the jury in with the attorneys.
Okay. thanks to the brilliant move of watching this in playback, we're going to get the verdict already. Only 8 people have voted so far, 100% guilty. So if you're not guilty or not proven, now is the time. I am, in the meantime, going to find my verdict music.
That the jury has reached a verdict. We have not yet brought the jury in. For the record, when I was notified that there is a verdict, I had our head of security here contact jail staff. Jail staff spoke with the defendant, told him that there was a verdict, offered him the opportunity to come over in person for the reading of the verdict, offered him the opportunity to listen or participate by audio or by Zoom for the reading of the verdict. He declined all of those options and indicated he had no interest. So, Shelley, let's go ahead and bring the jury in. Okay, the record will reflect that we now have the jury back in the courtroom with us. The attorneys are present. It is Friday, July 19, 2024 at 1:51 p.m. The jury has informed the court attendant that they have reached a verdict. I see that the foreperson has the verdict with her. Ma'am, can you please hand that to the court attendant? Okay, this is the state of Iowa versus Tyler Dazey, FECR 153723. As to count 1 on the charge of murder in the first degree, we, the jury, find the defendant, Tyler Dazey, guilty of the crime of murder in the first degree. That verdict form is signed by the foreperson. As to count 2 on the charge of animal abuse, we, the jury, find the defendant, Tyler Dazey, guilty of the crime of animal abuse, and that verdict form is also signed by the foreperson. Is the state asking that the jury be polled? Is the defense?
We better, Your Honor.
Okay, so folks, the court attendant will poll you by reading your juror number. When she reads your number, she'll ask whether you can confirm that this is in.
Okay, I've got a screaming cat, but we're just going to ignore him. So we don't need to see them being polled. Guilty, guilty, guilty. I don't know how I feel about the sister. Something is strange there. One sec. So that was a quick one. Awful audio. I cannot do that again. That is ridiculous. If it happens next time, I'll have to get it transcribed or something, and I will read it myself, because seriously, that was ridiculous. I'm not going to end now, though. I've started a new stream. Let me just quickly hit that on. Okay, I am going to portal you over, so you don't have to do anything. When I hit end stream, it's going to send you there. If you're impatient, you can click go now. But we're going to hang out there. It's just for the sake of people who are watching this after. They don't have to stick around for the whole part of court watching. All right, I'll see you there. Hang tight.